Just a very brief introduction to our keynote speaker for today, who I'm sure everyone already knows anyway. Professor Richard Susskind, OBE, President of the Society for Computers and Law and Chair of the Advisory Board at the Oxford Internet Institute. Since 1998, he's been Technology Advisor to the Lord Chief Justice of England and Wales. He's written 10 books, and I'll mention, well, Tomorrow's Lawyer, and of course, most recently, Online Courts and the Future of Justice, which of course we've just been talking about with Jeremy. Of course, we should also mention The End of Lawyers and make sure we emphasize the question mark at the end of Lawyers as well. He's a fellow of the Royal Society of Edinburgh and of the British Computer Society, and he holds professorships at Oxford University, Strathclyde University, UCL and Gresham College. And I think one thing we should also emphasize as well, Professor Susskind is the world's most cited author on the future of legal services. So, Professor Susskind, over to you.
Thank you very much, Steve. Good day, everyone. I'm currently sitting just in the outskirts of London in a place called Hertfordshire in my study at home. And I was joking just before I come on saying I've been locked down here for 23 years, but my life is very much devoted to thinking about the future of legal services. And what I thought I wanted to do today was to ask a simple question. What are we training young lawyers to become? Because it seems to me that that's the vital issue that we should address in the future of legal education. And I'm going to take quite a long run up on this. I don't want to address the question directly and immediately. I'd like to reflect, first of all, on developments that we're seeing in the legal market generally, say a little about how it is that technology is changing our world and in turn changing the way that lawyers work. Then I suggest to you that the law, as in most professional services, is evolving through various stages. And I want to give you a model of evolution. I'll say something about online courts. Then I'll turn to artificial intelligence and how it's likely to change our work and what the impact that will have on jobs. And that then will allow me to answer the question, what are we training young lawyers to become? Because what I'm trying to do here is suggest to you that in all aspects of our legal world, we're seeing fundamental change. And our challenge is to ensure that we're preparing the next generation of lawyers for these fundamental changes. Some of you may have heard of the story of Wayne Gretzky, the great ice hockey player, who apparently was asked, why are you such a great ice hockey player? And he said, it's because I skate to where the puck is going to be rather than where it once was. Now, I think there's a similar lesson here in the world of legal education. Our collective challenge is to see or to try and determine where that metaphorical puck is likely to be, and so we can direct our legal education accordingly. So that's really what I'm guiding you on the end position of the puck today. That's what I want to suggest to you. So let's start with the market. I used to say, and certainly in my book, Tomorrow's Lawyers, both editions, that there were three main drivers of change in the legal world. I call these the more for less challenge, new providers, and technology. The more for less challenge being this increasing pressure in costs that we're seeing, even in the largest organizations, which I trace back to about 2003, 2004, such that clients from the largest international organizations right through to the individual consumer would like more legal service at less cost. It's true right across the professions. That's one huge driver of change. It'll underpin, it'll define the delivery of legal service, in my view, in the coming decade. A second key feature is that the coming to the legal world of new providers, enabled in some jurisdictions by liberalization. And I'm referring here to the big four, alternative legal service providers, legal tech startups, and so forth, competitors to traditional providers of legal service. And thirdly, I talk about technology, and I will do in more detail very shortly, but this clearly a driver of change in society and our economy generally. There's no reason to think that somehow lawyers and the law and courts are immune from this. But I've had to add over the last few months a fourth driver of change, and that is the virus, COVID-19, because what we're seeing here, I think, in consequence is an acceleration of many of the advances I've been predicting for years. So that I'll talk about online and virtual courts. this current difficulty doesn't even begin to describe it, this tragedy in which we find ourselves has required us to think very differently about how we can use technology in the delivery of court services. So this was very much on people's agenda a few months ago, but now it's been accelerated. So the accelerating effect of COVID-19, it will actually also accentuate and exacerbate the more for less challenge, as well as, I think, require us to use technology more rapidly. So that's the broad background, that we see a marketplace very much in flux. And if you think of the many firms, law firms around the world, just for example, those that I advise, they're moving fairly rapidly away from their traditional consultative advisory model where they build by the hour. They're trying to embrace new ways of working, introducing new efficiencies, using new labor models, changing the way they deliver legal services. And so I don't want to be too prescriptive or descriptive about how this future is and ought to evolve, but I want to say to you that if we think we're feeding lawyers into, for example, law firms as they functioned in the 90s, this is misconceived, because these various pressures are bringing out a very different approach to delivery of legal service. And in relation to technology, I believe really, or change more generally, we're moving in the legal world through 3 stages, and we're coming into the 3rd stage just now. The first stage, which I think ended in about 2016, I call the stage of denial. And that was when lawyers around the world, judges around the world, denied that in any way, or any substantial way, that the legal world needed to change. There were arguments made for legal services and court services being significantly different from other services and not susceptible or amenable to technological change. And very strongly, and it might seem bizarre now, but only 4 years ago, you had leaders across the profession denying there were any real substantial changes in the offering for the legal world. Then came stage 2, which I called resourcing. And this is the stage, and it started actually about 2010, so the stages overlapped, and we're coming to the end of that, which essentially are new labor models, where within law firms, people thought about outsourcing and offshoring and subcontracting legal work, essentially taking routine and repetitive work and wondering if there might be ways in which, frankly, lower cost people in lower cost countries could undertake some of this work. And so people were sending in large scale litigation or in major due diligence exercises, sending huge volumes of documents off to India or the Philippines. And there was built up considerable expertise in processing large numbers of documents. But the idea was fairly straightforward, that clients didn't want to pay for expensive young people in expensive buildings in expensive cities to do what was perceived to be routine, repetitive, administrative, process-based work. And this, of course, is a running trend. We're going to see more and more work packaged up and delivered by others. But the fundamental shift, actually, which is, in my view, going to come this decade, is not where we use lower cost labor to undertake this more routine work, but actually when we use a variety of technologies. And that's the stage of disruption. And I'll get back to these particular technologies, the enabling technologies, shortly. But just to give you a sense of the trajectory, a move within a decade from fairly firm denial to the deployment of lower cost labor, and really at the threshold now of using increasingly capable systems to undertake at least some legal tasks and activities. Biggest picture, what we will see is a transition in the legal world from legal service as a form of advice to legal services delivered as products and solutions. In an internet-based society, when so much service is received and delivered across the internet, where we're finding ways of packaging and presenting and making complex knowledge available and more easily accessible, in a world also where, with all the will in the world, so many legal problems that people face in small businesses as individual consumers, even in large businesses, are difficulties that others have faced in the past. We'll see this move from advice, one-to-one consultative advice, to the development of products and solutions. We've seen it in other professions, in tax, in audit and consulting, and I believe we'll see it in law too. And all of this, of course, is enabled through technology. So I want to say a little bit about technology. And the first observation is to draw a fundamental distinction, which I'm going to apply to law firms, and it applies equally to education. And that's between what I call automation and transformation. Automation is what many people think of when they think of technology. They think of taking some kind of task or process or activity and streamlining, optimizing, improving, turbocharging it, not fundamentally changing it, but essentially grafting technology onto our old ways of working. And that since, frankly, the 60s, where we saw the birth of legal technology, that is how legal technology has progressed for the last 50 or 60 years. We've used technology to automate our old ways of working. But there's something far more challenging and more interesting, I believe, in the world of technology, and that's transformation. That's when you use technology not to sustain and support our old ways of working, but actually to allow us to do things that previously weren't possible or even conceivable. That's the power of technology, ladies and gentlemen. And as I say, this applies not just in the practice of law and the delivery of court service, it applies to in education. Our challenge in using technology across the world, across all markets and sectors, is not simply to create mess for less. That's to say, to automate our rather inefficient pre-existing processes, but it's to find ways that we can deliver the outcomes that are required using the power of technology to allow us to do this in different ways. Now, the power of technology, all technologies have different ways of capturing what's going on out there. I say that we can best understand what's happening in technology under four headings. We're seeing an exponential, explosive growth in the underpinning technologies, firstly. Secondly, our systems are becoming, and this is one of my key phrases, increasingly capable. Barely a day passes that we don't hear news of some new tech app system or breakthrough. Our systems are doing more and more, and often taking on tasks that in the past we thought could only be taken on by human beings. Our systems are also becoming, thirdly, increasingly pervasive. Not just the handhelds and the tablets, but the Internet of Things, chips embedded in everyday objects communicating with one another and with us as human users. And finally, we as human beings are becoming increasingly connected, communicating, collaborating, cooperating in new ways. If you add these four together, you find a very different landscape for our society and economy. Underpinning technologies growing at an exponential rate, our systems becoming increasingly capable, these systems becoming increasingly pervasive, and we as human beings communicating in different ways because we are increasingly connected. If you take, for example, just an illustration of the exponential growth, the little memory card that one might put in one's camera. 2005, a good memory card was 128 megabytes. 2014, less than 10 years on, 128 gigabytes. That's more than 1,000-fold increase in less than 10 years. And just last year, we saw the emergence of 1 terabyte. That's 1,000 gigabytes. We're seeing this remarkable explosive growth. It's not just in terms of storage capacity, it's in terms of processing power, bandwidth, number of websites, internet users, and so forth. In terms of our systems becoming increasingly capable, we've seen the advent of systems that are, and more on this in a few minutes, enabled by data. And so to give you an illustration in law, there's a system that was developed in Stanford and bought a few years ago by LexisNexis called Lex Machina. Now, many things are said of Lex Machina, but one of the things that's said is it can predict the outcome of patent disputes more accurately than any human lawyer. Now, that's a remarkable claim. And many people say, well, hang on, this is dangerous because this system knows nothing about the law. And that's true. It doesn't work through large volumes of past case reports. What it does is it has a couple of 100,000 records of past cases, who the judge was, the lawyer involved, the law firm, the size of the claim, the nature of the claim. It turns out using computational statistics, you can make more accurate predictions about the outcome of court cases than by using the legal method. That's the challenge that we all face, that we are developing methods that allow us to do things in entirely different ways. And we can have a debate about that, but I want you to know that this field that's emerging of electronic, as it were, prediction of judicial decisions could have a profound effect on legal practice. In terms of our systems becoming increasingly capable, we're also seeing the emergence of something called affective computing, machines that can both detect and express humans' emotions. A machine that can look at your face and tell whether or not you're happy, surprised, or angry, or disgusted. There's a system now more accurately than any human being can listen to two female voices and know whether or not they belong to a mother and a daughter. There's a system more accurately than any human being can look at a human smile and tell whether or not that smile is fake or genuine. Now, these are big advances and big changes in technology, and bear on, as you can well imagine, our conversations about what it is we can achieve through online and virtual courts. We're also finding new ways, as I said, of collaborating, and I'm not just meaning, and it's been remarkable, the uptake of the kind of technology we're using today, but the use, for example, of social networking in the professions. Patients like me, more than 600,000 patients online, many of them chronic sufferers, and many of them too saying that not only do they receive more, I suppose, empathy and sympathy from fellow sufferers, but they also receive more practical guidance. So a first port of call increasingly for people who have difficulties that are fundamental to their lives is often not the professional advisor. It's a community of people, like-minded people, who faced similar difficulties in the past. I throw these ideas out just to give you a sense of how rapidly technology is changing. And the kicker in all of this is there's no finishing line. No one in Silicon Valley or China or South Korea is saying, job's done, technology progress is coming to an end, or we're even plateauing. It's nothing like that. What we're seeing is an accelerating uptake of technology and accelerating development of underlying technologies. And this is enabling, I believe, an evolution in professional service, an evolution of service away from a bespoke, handcrafted service through a service, and we're seeing it not just in law, we see it in medicine, in audit, in tax, in architecture, in teaching too, that we've moved from a highly bespoke one-to-one craft to depend often on standardization of process and of substance, and then systematization, where we've found technologies that allow us to take the more routine and repetitive elements and really apply technology to these. Now, with the advent of the internet and the web, we've seen not just a systematization of knowledge, but that knowledge and content, advice, documents, and materials can be made available online in one of three ways at least. First of all, as some kind of chargeable online service. So you see in some professions, like consulting and tax, you can gain access to tax expertise. More than 50 million people in the United States now use an online tax system rather than a human tax advisor to submit their tax returns. Very few of them, I understand, are lamenting the loss of social interaction with their tax advisor. That's not the issue. The issue is that people have found a more practical way to deliver the outcome they require, which is the use of this online service. But some online services, very useful ones in the professions and law too, are available on a non-chargeable basis, produced by governments, by charities, by educational bodies. And then finally, there's another model of which I'm rather idealistically a fan, and that's the idea of the commons, where you actually have, in the spirit of Wikipedia, professional knowledge and expertise from which anyone can draw and to which anyone can contribute, subject to a kind of collective editorial process. The key point is that we're seeing, in summary, a kind of commoditization of human knowledge and expertise away from a service that's delivered as a craft in some, but absolutely not all, circumstances to some kind of online service. So let me turn now to say a little about technology in the courts, and the previous speaker, Jeremy, touched on this too. In outline, at this moment in time around the world, our current system, our court system, is not coping, and it's not coping for three reasons. The first is that many courts are closed because of the virus. The second is that very large backlogs are building up, even in the UK, where I think our use of technology has been, by and large, fairly successful, and that's confirmed, for example, by research for the Civil Justice Council that interviewed 1,000 lawyers who'd used alternative ways of hearing cases. But even then, I think we were only coping with about 35 to 40% of our cases. So there's a huge backlog building up. So courts are closed, there's a huge backlog. And also we have, and we can't forget this, the traditional access to justice problem. And this is what actually preoccupies me, and I think it's something I'm fascinated to try and use technology to help. According to OECD figures, only 46% of human beings live under the protection of the law, have realistic access in our world to lawyers and courts, less than 50%. Indeed, therefore, more people have access to the internet than have access to justice. In some jurisdictions, we've got staggering backlogs. 80 million cases in Brazil, 30 million in India, for instance. But even in the most advanced court systems, if you take civil disputes, for example, most civil disputes, particularly low-value ones, cost too much, take too long. The process is unintelligible unless you're a lawyer, and somehow, and increasingly, this feels out of step in a digital society. I argue we need a new mindset if we're going to crack these three problems, if we're going to cope during the crisis, if we're going to cope with the backlog, and if we're going to meet the access to justice challenge. And I say the new mindset is to ask this question: is court a service or a place? Do we really need physically to assemble on all occasions and hear oral argument to resolve our legal differences? Or might there be technological options? Now, we've certainly seen over the last 3 months the emergence of technological options. Because physical courts were shut, what we're calling remote courts have sprung up. And for those who are interested to track this, I founded something called Remote Courts Worldwide. It's the website's www.remotecourts.org. And what we're trying to do there is gather together news from as many countries as possible about how they're coping with the move from physical courts to remote courts. And I think we've got about 56 countries there already feeding in. If you rewind just over a year and a half to December 2018, when we held the first international conference on online courts, we had 26 countries and 300 delegates, but hardly any systems at all. And now all these systems have sprung up in these extreme circumstances. How's it all gone? I think they're, in the broadest of terms, better than most lawyers would have expected and predicted, say, in January. But it's early days. But what we're seeing is the emergence of three types of alternative to the physical courtroom: the audio hearing, the video hearing, and the paper hearing. The audio hearing is basically using telephone conferencing to conduct hearings. That's the comfort zone of many judges and lawyers. I don't think there's any question that in most circumstances it's not as good as the video hearing. The video hearing, using technology not unlike the technology we're enjoying, I hope you're enjoying today, the video technology enables us to come together and conduct hearings, it turns out, to by and large a fairly satisfactory standard. And then there's a paper hearing, which I've written a lot about, which is the idea that there's no hearing at all, in fact, but evidence and arguments are submitted electronically to a judge who responds in kind. And so it's what they call an asynchronous process. You don't need to be together at the same time to communicate. But these three categories that are evolving, the audio hearing, the video hearing, the paper hearing, each in different ways are bringing surprising benefits and also have considerable limitations. But all of this is challenging stuff. Judges without courtrooms, justice without lawyers, because we're seeing, for example, in paper hearings, if you look at the Civil Resolution Tribunal in Canada, which is the leading example, this is a system that allows people to use a public state-based dispute resolution service without lawyers. It's been designed not by lawyers for lawyers, but using techniques such as design thinking to ensure that non-specialists can use these systems. All sorts of objections, of course, raised and have been raised. I think with less force now than, say, when I wrote my book in 2019, when it was published, Online Courts and the Future of Justice, where the reaction by and large was one of deep skepticism. So people said, what you're doing here really, in the name of access to justice, is producing an economy class service. The first class service is the physical courtroom. The electronic version is economy class. people also said, hang on a second, this isn't open justice. How is this transparent? There's no physical courtroom to walk into. Some even challenged whether or not it was a fair trial because it strictly wasn't being held in public. Others said, you've got to remember about digital exclusion. There are those who haven't got access to the internet. Still others said, this is encouraging litigiousness. It's making the access to the court system, tribunal system too easy. And then there was what I call a jurisprudential miscellany. I used to teach jurisprudence, so this is of interest to me. People said that the emergence of online courts in a variety of ways threatened the separation of powers, that it was a move from an adversarial to an inquisitorial system, that the notion of litigants without representation was fundamentally flawed, and indeed that the common law system itself was under threat. Perhaps the most compelling objection is, hang on a second, folks, this is a public sector technology project, and most public sector technology projects fail. Now, that range of objections, I spent about a quarter of my book addressing. It won't surprise those who are listening to say that I think none of them are knocked down arguments. They're all important and significant observations. But I would say that often critics, when looking at the alternative physical court systems, mainly lawyers, the critics, fail to look at the system through the eyes of users. They look at what's been proposed through the eyes of lawyers and forget just how inaccessible and unintelligible the conventional system is. More importantly, in the name of justice, and it's true that almost everyone who objects to online courts invokes concepts of justice, just as it's true that everyone who supports online courts invokes concepts of justice, different conceptions of justice that transpires. But in the name of justice, critics miss the opportunity to reduce injustice. This has always fascinated me, that when we talk about the future and the use of technology in courts and law offices, there's a tendency of well-intentioned but very bright lawyers to compare what's being proposed against some kind of idealized, perfect model of court service or legal service. But we shouldn't really be doing that. We should be comparing what's proposed against what we have today. And what we have today is a largely inaccessible and unaffordable system. And so I look for improvement rather than perfection. I don't look for some kind of perfect system. I'm interested in how we can use technology to improve the current state of affairs. What does the future hold with courts? Well, looking further ahead, I can see, and I've written about, but I simply put this as a thought, I could see the resolution of disputes in some form of virtual reality, and I can certainly see the increasing use of AI within the court system. And so the thrust of what I'm saying here, and it's true of legal practice too, I'm saying we're moving at a time of unprecedented change, and we have to make sure that the new generation of lawyers who are coming through are fit for purpose, fit for the new purpose, fit for the new world. So in law, if we're seeing, as I believe we will see within a few years, a shift from the presumption that all disputes before courts are held in a physical space to a new presumption that by default cases should be held and conducted remotely unless there are compelling reasons to assemble in the courtroom, you see this is a very different landscape into which our young lawyers are moving, a landscape in which they may not be much of the time at all pleading in courtroom in the traditional way, but they'll need to learn a new set of skills as they support clients online. For those of you who are interested, and as I say, I used to teach jurisprudence, so it's a particular interest of mine, but it's just to give a flavor and microcosm of the difficulties we face, I think, in legal education. The response from mainstream jurisprudence to the possibility of the advent of online courts has been negligible. And this completely amazes me. One of the fundamental issues that we address in jurisprudence is how do judges come to decisions? What's the function of the court system? And most jurisprudential classes, I love this stuff myself, are teaching jurisprudence from the 70s and 80s. And the theory there is important, but the object of study has shifted. Not only that, I believe we can use the philosophical insights we get from jurisprudence to understand more about how it is we might best change from a physical to a remote environment. Let me say something about AI and jobs now. Everyone's talking about AI. I wrote my PhD in Oxford in AI and law in the 80s. So this is my lifelong interest. And just to put it all in context, because there's so much guff spoken, my own view is that most of the short-term predictions made about the impact of AI and law hugely overstate its impact. However, most of the long-term predictions, I believe, hugely understate its impact. So will AI fundamentally change the law over the next 2 or 3 years? Not at all. By 2030, will it have a major impact? I truly believe it will. Let me take a little bit of time travel to the first wave of AI that I was involved with. A man called Philip Capper, who was the chair of the law school in Oxford, and he'd been one of my examiners, sent me this. It was an extract from a piece of legislation called the Latent Damage Act 1986, and it read as follows. Section 2 of this act shall not apply to an action to which this section applies. I've read that quite quickly and it sounds unintelligible, but if you see it written down, it's no different. And he said there's this new piece of legislation that's emerged. It fundamentally changes the law of limitation, and no one's really understanding it. It's a complex web of barely intelligible rules. And he said, why don't we use the techniques you developed in your doctorate and see if we can develop a system that can answer the question, in cases of latent damage, what's the date after which I can no longer raise an action? So we developed this system. The latent damage system, it was called. These were the days, ladies and gentlemen, when floppy disks genuinely were floppy. It was delivered in 2 5.25-inch floppy disks. It was like a huge decision tree. This is how you developed AI in the 80s. It was like a huge flowchart. More than 2 million paths through this decision tree that we manually developed. And essentially, this was a system that could take your hand and guide you through an extremely complicated area of law. Many of the systems that are used, for example, for tax compliance on an international basis, use these same techniques and technologies. But this was developed in the late 80s, and the system in the end, Philip said, was better than him. It reduced research time from hours to minutes, and it somehow spoke like a lawyer as well. We designed the system in a way that the language it used was broadly familiar to legal practitioners. The idea was this was a system for general legal practitioners to gain access to a complex area of law. So this was possible over 30 years ago. There's a few things we didn't anticipate. One was the web. The web came along in the early 90s. It's hard to convey to you, though, to those of you who weren't of an age at the time to, basically too young to see that something very dramatic was happening. But if, like me, in the early 90s, you were about 30, you thought, oh my goodness, this is just completely amazing that you can sit down at your laptop, that you can connect not just other people, but to endless resources and services, and you can link documents to one another and navigate around them. It was just unimaginable, this leap. And of course, we take it for granted today. So we hadn't anticipated that. But what happened is most people who were working in AI and law went to work in law on the web, because this was a more intuitive, pragmatic, commercial way of immediately making content and guidance available online. We also didn't anticipate brute force computing. This goes back to the exponential increase in the processing power of computers. So a lot of us were then drawn back to AI when we heard about Garry Kasparov, the world chess champion, being beaten by a computer system called Deep Blue. We thought, oh my goodness, again, what's happening here? And what was happening was a computer system that could explore more than 330 million possible moves in 1 second. Good chess player can juggle about 100 moves in his or her head in one moment in time. So we didn't anticipate brute force computing. And we also didn't anticipate the new wave of AI where we don't program systems at all. You don't code in 2 million paths through a complex area of law. These are systems that learn. They learn from huge amounts of data. And it's a bit like when you learn a language, 2 ways of learning a language. When I was at school, I learned a vocabulary, rules of grammar, and the end product of my French speaking was rather low quality. Other friends went off to Paris for the summer and came back fluent. They didn't know rules of grammar. They couldn't remember learning the words. What they did was absorb huge amounts of data, and somehow the system, that's to say the brain, imposed some kind of structure in that. And that's the difference between the old form of computing, explicitly programmed, and the new form that learned from data. And that's why systems can predict the outcome of disputes more accurately than human beings, because they have far larger amounts of data at their disposal. People say to me, but what about judgment? How can a computer system ever exercise judgment? Because that's what we do as lawyers. And I say, you're asking the wrong question if you ask that question. The bigger question is, to what problem is judgment the solution? That's to say, why is it that we exercise our judgment in the first place? I hear of very few law firms where clients come in the morning and say, good morning, I'd like some judgment, please. That's not how it works. Judgment is not the end thing, the outcome that's wanted. People have problems and difficulties, and judgment is a faculty, a facility, a tool that we use under conditions of uncertainty. Judgment as humans is one way that human beings handle uncertainty. So the question is not so much, can a computer system exercise judgment, is can a computer system handle uncertainty? And again, the answer to that is you bet, because that's what huge amounts of data allow these systems to do. So we're seeing the emergence, I believe, of increasingly capable non-thinking machines. These systems, I have to stress, have no more cognitive states than the floor beneath you. But what they're doing is they operate in entirely different ways and can produce outcomes at the level of human beings. What does this mean for jobs? Well, here's a list of jobs. And this comes from my book, Tomorrow's Lawyers. Legal knowledge engineer, legal technologist, legal hybrid, legal process analyst, legal project manager, legal data scientist, the R&D worker, the ODR practitioner, the legal management consultant, the legal risk manager. The details don't matter. But when I put up this list, I say to lawyers, who are these people? And I say, in response, these are the people who'll be building the systems that will be solving the problems for which today you're the only answer. These are the people who'll be developing systems that will replace our old ways of working. These are tomorrow's lawyers. Now, this is anathema to many lawyers. So, well, hang on, this isn't what I learned at law school. This isn't what we do in the law office of the court. But I don't think we should define legal service in terms of the methods we've used in the past. We should surely be focused on those we're helping, the clients. And if the dominant way we come to help clients in the future is by more advanced systems, then it seems to me the legal profession, and it's true of all other professions, becomes the profession that builds these systems that replaces our old ways of working. So what then does all of this mean, to get to the point, for legal education? What I've tried to do today is track you through some of the developments we're seeing. We're seeing a marketplace under unprecedented pressure, these drivers of change, the cost pressure, the new competitors, technology, and now COVID. We're seeing the emergence in law firms of new ways of coping with routine, repetitive work, all of which used to be the work that the young lawyer would cut their teeth on. We're seeing the evolution of more advanced, ever more able technologies. We're seeing a shift from legal service as a bespoke service to an online service. We're seeing in the courts a move from the physical courtroom to remote and online hearings. And we're seeing the emergence of AI systems that can take on tasks that used to be the exclusive province of lawyers. So in the context of that, I ask the question, what are we training in very large number these young lawyers to become? Are we training our lawyers to become traditional one-to-one, bespoke, face-to-face consultative advisors who specialize in individual jurisdictions and charge by the hour? Yes. Are we building flexible, team-based, commercially astute hybrid individuals able to transcend legal and professional boundaries? Not at all. We're in the 2020s when all these jobs, the legal knowledge engineer, the legal risk manager, the data scientists and so forth, are so terribly, I think, are going to be the terribly important jobs of the future. We're not training our young lawyers to become any of these jobs. We have had massive reviews, and I've been involved with the big one in the United Kingdom, the Legal Education and Training Review, and I've been involved recently in one for the American Bar Association. But if you look at the UK, in many law schools, the laws taught it was as it was in the 70s. Very little acknowledgement of globalization, commoditization, AI, business management, alternative sourcing, online courts. Now, it's often said, rather disparagingly by practicing lawyers, that many law graduates, even say 10 years ago, when they emerged from law school, were ill prepared for legal work of today. They're still less prepared for legal work of tomorrow. So should we extend the remit of law schools, of colleges, and in continuing education to include other disciplines, such as risk management, project management, legal knowledge management, and say of disruptive legal technologies. Is there a place for the future in busy law curricula and law firms training programs? I was struck when I went to China in 2017 and I had given a talk to about 600 people. There were a few students, half a dozen students came up to me afterwards. They were all doing PhDs on artificial intelligence and law. And I just reflected there is no one at that stage was doing a PhD in AI and law in the UK. We're not preparing our next generation. We're not undertaking the research. You could also frame this issue differently. What are the reasonable expectations of students who pay for legal training? It was my frustration with that topic that led me in 2013 to write a book called Tomorrow's Lawyers, which was precisely to help young lawyers understand the trends and to give them the questions they should ask of those organizations that might employ them in the future. And what was fascinating is that that book was embarrassingly out of date within 4 years. Or 3 years. I needed to write a new version. My recommendations in this have always been quite modest because I'm conscious of how busy the curriculum is. And I'm conscious, again, this is my jurisprudential background, that I do want law students to be exposed to more than legal practice. I think it's important that we engage in theoretical, abstract, critical, philosophical thinking too. So I'm not saying you junk the current law curriculum, but I think we should provide aspiring lawyers with a couple of options. I think when anyone is undertaking a law degree, they should have an option available to study current and future trends in legal services. There's a literature in that now. And they should also have the option to learn 21st century skills that will support future legal work. Now, I know in a small number of universities have actually done this. These options are incredibly popular because people are investing in their own lives, they're investing in their careers. And so in a way, I'm asking young law students to work harder, but I'm asking them to invest in their own future. But we, as law professors, as legal education providers, have to make these options available. Also, we have to think about how are we training young lawyers to become tomorrow's lawyers. So I would say it's not just what we teach, it's how we teach. Are we using 21st century or 20th century methods? I'm almost reminded of the astronaut when I think about this. So when the astronaut takes his or her first flight, sits in the capsule, they don't look around and say, oh, wow, this is what it looks like. This should be an interesting voyage of discovery. Rather, they have been in simulators for many, many years. And it seems to me the answer to the future of legal education is going to be creating simulated practice environments in which people can immerse themselves, a kind of virtual reality, as well as courses, online lectures and so forth. But if we're thinking of seriously upgrading legal education, it's not going to be through automation. It's not going to be, as I mentioned earlier, by streamlining, improving our old ways of working. It seems to me it's by using technology to allow us to create learning environments that previously weren't possible or even conceivable. And many of you will be familiar with the work of Paul Maharg, whose early work in this shows how possible this might be. Just a couple of final thoughts. In 2017, I was invited to Boston to speak to 2,000 neurosurgeons. I'd written a book with my son called The Future of the Professions, and we were talking quite a lot about the future of healthcare. And they asked me to be controversial. It's a scary audience, 2,000 neurosurgeons. So I stood up and said, patients don't want neurosurgeons. Gasping audience. I said, patients want health. Now, for a particular type of health problem, I've no doubt that you are the best answer. But that might not always be so. I said, I suspect you invited me here as an AI guy to talk about robotic surgery. But do you not think in 50 years, I said, I don't know if it's 20 or 70 years, we'll look back and think it's unbelievable we used to cut bodies open? Because the future of healthcare is non-invasive. And this led me to think quite a lot, and I write a chapter of my new book about outcome thinking, that actually we focus too much on how we work rather than the outcomes our clients, our patients, the recipients of service require. And often we preserve and perpetuate our traditional ways of working without regard to their outcomes. And I think if we think more about outcomes, we then realize we're asking very often the wrong question. So people often say to me, what's the future of lawyers? And I say, not facetiously, but that's the wrong question, because that assumes that lawyers have a future. Surely the question is, how in the future will we be solving problems to which lawyers are currently the best answer? And I've given you a hint of that today. It's the same in the future of legal education or the future of law professors. It's not, the question isn't what's the future for law professors, it's how in the future will the benefits that law professors and legal education bestows be delivered. And I doubt it will be in the way we've delivered it in the past. So all my thinking in this is conditioned by, and those of you who've heard me speak before will have heard me say this, but I want to leave you with this thought. It's the story of Black & Decker, who apparently, when they recruit new executives, take them off on a course and put up a slide of a gleaming power drill and say to the assembled new executives, this is what we sell, isn't it? And everyone says, of course, that's what we sell, we're Black & Decker. And the trainers with some satisfaction say that's not what we sell, because that's not actually what our customers want. They put out a new slide, and it's a slide of a hole neatly drilled in a piece of wood. And they say that's what our customers actually want. And it's your job to find ever more creative, imaginative, competitive ways of giving our customers what we want. So when we're thinking about the future of legal education, ladies and gentlemen, let's not think this is about a quicker, cheaper, lighter power drill. Let's think about the hole in the wall. What's the fundamental reason we exist, those of us who are involved in legal education? And might we deliver the outcomes that we need in this rapidly changing world in entirely new ways? Thank you very much.
Thank you very much, Richard. That was a lot to think about. So thank you for probably being quite kind to the law schools as well, and referring that some law schools are turning out lawyers for the 1970s. That's probably quite generous at times, isn't it? So interesting for us in many ways. I'll just remind everyone, I didn't at the beginning, if you've got questions for Richard, please chat them in, because I think we've stopped all of the audio to provide some sort of audio sanity. Otherwise, we'd have lots of people chatting at the same time. So if you chat them into me or to Richard, then we can answer the questions. I've already got some here, but just one for you from me. We've been developing new courses for our students, which start in September, to do with law and technology. And we've been talking to practitioners, and we've got practitioners who are involved who are using technology as well. But we've heard different things from practitioners as well about what they expect that they're going to have to do as practitioners. You mentioned there this idea of team-based. And I think isn't that the important thing? I've seen the ads for legal technologists and others, but I've heard some practitioners saying, I'm getting all of my lawyers to learn about coding. Now, do you think that's the important thing? Do they all need to learn about coding, or do they work with people who actually do coding?
It depends on what one means by coding. But if you're saying that, and a lot of people do say this, that it's important for lawyers to learn to program a machine in quite a low-level programming language, I think that's nonsense. I really do. I think what is important is that young lawyers, for example, learn to use tools that are available. So if you take something like document automation, if you're learning how to draft, you should learn how to develop a document automation system. Now, in a way, that's like a high-level structured programming language, but it's not low-level coding. But that requires you to be systematic and structured, methodical in the manner of programming when you're organizing and developing a system that's going to be generating legal documents. And that's a great intellectual discipline, and it's akin to programming. But the idea of lawyers needing to code seems to me to be a bit daft. I don't think surgeons who use these advanced systems or doctors who use diagnostic systems, we are being provided with, the story of computing is taking us more and more away from ones and zeros. And people will provide layers and layers on top and provide us with tools. What our lawyers need to know is they need to be confident users of the tools that are emerging. So another area, if we're involved with data science, I don't think it's for young lawyers to be trained in writing the algorithms for data science, but they should be able to they should have the skills to be able to gather huge amounts of data and apply the algorithms that are out there to that data. There's an argument that it gives you some sense of the discipline involved in programming, but programming itself is there's so many activities involved in computer science. It seems to me to be a rather bizarre development. That said, one of the reasons I think jurisprudence is important is because it's important for its own sake, as something intellectually that's valuable and interesting. And actually, having learned to code myself in the past, coding is similar. It can be fun and enjoyable. So I don't want to discourage people doing it as an intellectual discipline, but your priority as an educator, when there's so little time, is surely to make the law students comfortable with the tools that are available rather than to help them develop the tools.
Great. I'm very grateful you said that, because I've been very worried about I'd have to go back to those early computer languages that I learned at the beginning of the 1980s and the dreadful days of the early days of computing. So thank you.
You probably learned BASIC, I can imagine.
And then Fortran and these other things. I seem to remember. It was a worrying time for me. So I'll read out some of these questions anyway that we've got in from you. Dr. Debbie Legg has said, what will the impact of a finite planet on the development of technology? What will be the impact of a finite planet on the development of technology?
Sorry, Debbie, or rather Steve, in addition to Debbie, what the impact of, I didn't catch the phrase.
What will be the impact of a finite planet on the development of technology?
A finite planet?
Yes.
Oh, so I wonder if you could help me.
Yeah, I don't know if there's
I presume we're talking about a planet with limited resources.
I think that's probably what it is, unless Debbie wants to.
I wonder if Debbie could clarify.
Yeah, well, let me move on, because Jeremy, who preceded you, of course, has got some questions that he wanted to ask, following on from what he said and from what you've said as well. So there is a sense of real desperation at the criminal bar in London as to the future prospects for jury trials. So Jeremy's questions are, can you envisage any circumstances in which criminal trial justice can be achieved virtually, bearing in mind the makeup, dynamic and objectives of the criminal courts? And he carries on, if not, how can the huge UK backlog and logjam within the criminal justice process possibly be addressed without inordinate and unworkable delay? And of course, what he's getting at there is the criminal justice system on the brink of collapse?
Well, there's all sorts of, Jeremy, we should, when the crisis stops, we should get together and discuss this over a coffee. I'm quite a vocal critic of the idea, for example, of virtual jury trials. For a number of reasons. One, there has, to my knowledge, has not been one ever anywhere, so there's no evidence of how it actually works in practice, although justice in the UK has been doing some interesting experiments. I'm not sure at a time of great societal uncertainty one wants to remove such a fundamental institution as the jury, whether or not one approves of the jury system. And so I wouldn't be rushing at this stage. I do think, though, that what we would in any event never want to do, I'm not dismissing the idea forever of serious criminal trials being held remotely. What I am dismissing is my automation argument. Simply dropping the current jury system into Zoom doesn't seem to me to be the answer. When we need to take a step back, and it's part of a public conversation about what the function of the public court system is, what values we're wanting to maintain, and whether or not these functions and values can actually be, in some sense, perhaps even enhanced, but certainly not copied, but made available through transformation rather than automation, whether or not we can use technology to allow us to achieve the goals of the system in new ways. So what I'm warning against is simply automating current criminal trials. I'm open to the idea of us thinking deeply about how it is we can dispose of criminal cases using the transformative power of technology. That's to say, allowing us to do things that aren't possible in a physical system. All of that said, I read that I'm talking about serious criminal trials there. If the virus keeps physical courts closed for years rather than months, and let's obviously hope that that doesn't happen. But we're in the land of undesirable alternatives, and there's a conversation, as Jeremy will know, about whether or not you could, for example, have a jury in a separate room, all socially distanced, high-powered video, and that's the fourth trial by Justice showed that. It seems to me that that's promising. There's the idea in either way cases, as they're known, that these cases could be decided by judges and magistrates alone. There's the idea, I think they're called diplock trials, of some cases being decided by judges alone. Now, none of these alternatives seems to me to be particularly satisfactory, but when you're in the land of, as I say, undesirable alternatives, one needs to choose the least unattractive. I do really think we should be putting I know there's a group has been put together to think deeply about how you can have a socially distanced criminal trial. I'd like to find this legal minds in the world to think about how we can have a virtual criminal trial, as I say, not simply by dropping the jury into Zoom, but by thinking if we can hear criminal cases in different ways. Now, for the higher volume, less significant crimes, there was a fascinating account by a magistrate that's available. You can see it in remotecourts.org, who said what it was like to conduct a hearing, a criminal hearing remotely, and it was a very positive experience. So I am inclined, given the power of this technology, and we'll have to have all sorts of safeguards in place, but it does seem to me that that lower courts around the world should be able to handle some criminal work remotely. Now, this is not entirely new, as we all know, because, and this has not been entirely satisfactory, but we've had remote bail hearings, remote manned hearings, and so forth, where prisoners have communicated from prison. It's quite interesting, actually, that the questions that arose then about should the lawyer be with his or her client in prison, or should they be in the courtroom? And that raises a question of whether or not a virtual hearing is a partial virtual hearing or a full virtual hearing. So a partial virtual hearing is where there is a physical hearing, but some people are communicating virtually or by video. A full virtual or full video hearing is when everyone is communicating by video. Now, my instinct, and I think the research is showing, is in terms of fair process, a full virtual or video hearing is likely to be safer and puts everyone in the same level playing field than the situation where some people are in a courtroom and others have a glimpse of that, are genuinely rather remote from it. And so I think if we are handling criminal cases, for me, it's not partial, it should be full virtual hearings. I say this in my book, though, I do think criminal raises very different issues from civil, because there is the instinct of many that it's not just a question of personal vindication, as often a person's day in court would be in a civil case. It's the sense in which the courtroom is a place where there's a kind of public condemnation of certain behaviors. And I understand people who think that's important, but I keep on stressing the point that video hearings can be much more public than traditional physical hearings. When you see during our Brexit hearing in the Supreme Court, there were 3 million people watching it online. That's a far more public event. And what I believe is that our conception of public will change. And in a way, the answers to Jeremy's question, it's partly a technical one about what's possible, but it's also a kind of social moral question about how it is that people in society would expect criminal behavior to be processed. And our instincts and intuitions about this, as people who can remember a pre-internet society, will not be the same as our children's. And so I think our answer to this question will change over time. I think we will look back and think it's unbelievable. We used to congregate physically for certain kinds of hearings where it's palpably fairer or more and more public to do it otherwise. So I don't, Jeremy, I really don't have the answers. My current advice to those who listen is that we shouldn't jump into simply having virtual jury trials. I think that would be an error at this stage. but we should keep an open mind to using that technology or this kind of technology for lesser crimes. But as I say, if the virus continues, we're going to have some very difficult choices to make. But I still insist that the virtual jury trial, for me, as conceived as a kind of Zoom meeting, is not one that would get my support.
Thank you. I think we've got time for one more question, and this is a legal education one. Many law professors learnt their law and their pedagogy in an analog age. Many also are most concerned with social and political issues. They have little or no practical experience. How do we then retool law professors, particularly those who have no interest in legal practice and technological change?
The second part of the question is funny. The first part of the question, I think this is no different from any other professions. We're all having to reinvent ourselves. I think the 2020s will be remarkable for that reason alone, that so many of our own old skills will become irrelevant. We'll have to climb learning curves. And of course, this has happened over the last 3 months with lawyers who've had to become confident in using video hearings. So I think, first of all, I would want a curiosity and a willingness to relearn. It's not relearn, it's learn about new disciplines and issues. It's quite interesting that on the second point about if you're not interested, I have never met a lawyer or law professor who's immersed themselves in legal technology and come out at the other end and say, this isn't of interest. This is not for me. We get quite a lot of what I call irrational rejectionism, which I define as the dogmatic dismissal of a technology with which the critic has no direct experience. We get the same in this. Technology is not something I'm interested in. I would find that a remarkable precept. Anyone who is intellectually curious, it seems to me, will be stimulated by discussions about artificial intelligence. If I can put a question that I put to my students, what it is a human judge can do that a machine can't, and you're away. You're discussing jurisprudentially and you're understanding the enabling technologies. And so what I would encourage people, because often this is a little bit of fear, and I fully understand this, the fear of the unknown, what I encourage people to do is take the plunge, is just immerse yourselves. There are enough online talks, there are enough books and articles, but what we perhaps need to do as a community is have a kind of starter pack which allows law professors to move from a fairly low level of understanding and appreciation, and that's not a criticism, but allows us to climb the learning curve quite quickly. The other thing I want to say about this, and I say this as someone who's apparently expert, and I have been doing this for almost 40 years, there's so much nonsense talked about legal technology and so forth. A bright law professor could grasp the main points of this over a weekend, not the detail. But what I'm saying is very quickly you can feel, and it's a great experience for those of. One of the things is one gets older, one doesn't have this experience of moving from being a beginner, a complete novice, to suddenly think, oh, I get it, I'm beginning to get the hang of this. Well, I think you can do that in legal technology over a weekend, and that of itself is fundamentally stimulating. But I don't think it's an option. I think if you want to remain relevant, what one needs to have a grasp. And the final thing I want to say is legal technology of itself is not one field. In stuff I've written, I've suggested that there are about 50 different branches of legal technology. Just as law is not one field, it's the same with legal technology. So you're able to pick and choose from things that may or may not be interesting. There's a wide buffet of options.
Excellent. Thank you very much. I think the experience of this conference, by the way, is, a number of presenters have been saying that people have been forced into using the technology, that they were really against the idea, but actually have come out of it saying, well, actually, this really works. And actually, there are exciting things we can do with the technology as well. So maybe there is a future for law professors as well in using technology. Thank you very much, Richard. It was a very interesting talk.